Hi, guys. Good afternoon, and welcome again to today's edition of The Law and You. I'm your host, yours truly, Attorney at Law Shellon Washington, admitted to the bar in the state of New York, and also admitted in my home country, Guyana, and in the Twin Island of Trinidad and Tobago. Today, we'll be discussing something which I think would be applicable to those people who are everything else is already set in your life. You have assets, and you will want to determine what next to do with those assets so that whoever is going to be left behind you wouldn't have to go through too much stress. So today we're going to be speaking about a will, using a will in a sense to protect those assets from the wrong people's hand and passing it down through your generation versus putting it in a trust. Now, let's talk about a will. What is a will? We refer to that will as the last will and testament of a person's wishes, meaning your desires. A will is your desires. Whatever those desires are, it's being expressed in writing, and those written words will be revealed upon your death. So we're going to talk about that. And I'm trying to scare anyone, because a lot of people, when they hear the word will and they hear about preparing a will, they often think about dying, and that's not true. That's not something that you should be concerned about when you're thinking about a will. This is something you're thinking about. You want to protect those assets so that it wouldn't fall into the wrong hands. And when I say fall into the wrong hands, I mean a lot of people don't know there's something called rules of intestacy. The rules of intestacy applies when a person die without expressing their wishes in a will and leaving those assets in their estate for the law to tell the estate what to do with those assets. So if you want to avoid the law having to tell your estate what to do with your assets after you leave this place, the best thing is to do is either do a will or a trust. Now, let's just break it down a little bit about the will for those people who are, not familiar with what a will is and how to use it, when to use it, and when not to use it. A will is a good tool to use if you don't have children, you don't have grandchildren, you don't have a surviving spouse, and it's just you. And you don't have anybody to really leave your estate to. But maybe you have distant relatives. Maybe you have a cousin. Maybe you have an uncle, an aunt, half brothers and half sisters, people who are not very close to you. Then a will is the best thing to use. Because if you don't use that will to express your wishes as to what you want to happen when you leave this place, the law will use the rules of intestacy and determine what happens to your estate. And what does the law of intestacy say? The law of intestacy say any person dying, leaving their estate without a will, it will fall in a certain order. The estate will be divided in a particular order. And what is that particular order? The rules of intestacy follows spouse first. If you don't have a spouse, then it goes to your children. If you have spouse and children, it goes to your spouse and your children. If you have neither of those, then it goes to mother, father. If no mother or father is left, then it goes to brother or sister. If none of those are left, then they start counting cousins and second cousins and aunts and uncles and grandparents. So there's a particular order in which that goes. But if you have none of those, then the estate is pretty much going to go to the state or maybe charity if you have no relative whatsoever under the sun, not even a distant cousin who can be traced to inherit your estate. So in order to prevent that, I'm pretty sure a lot of you seen cases where people left an entire estate to an animal, a cat or a dog. You have that ability to choose to do whatever you want to do with your estate while you're still alive. Because if you leave without expressing those demands in writing, like I said, the law will determine it for you, and the law will make the decision based on the rules of intestacy. So now, let's say you belong to a church, but you don't have any relatives, and you want that church to inherit your estate when you're no longer here. You make a will. You express that in the will. You say after your death, that the church will inherit your estate, and you appoint an executor under your will. You elect somebody who you would like to serve as your executor, and you say, once you're gone, this person is going to be responsible for administering your estate. Something else you need to be aware about appointing an executor under your estate is that the executor has to be compensated. A lot of times people think the executor works for free and he or she is not entitled to anything, but that's not true. The executor is entitled to compensation. In the state of New York, you get a certain percentage that you can't go over as an executor, and that's what you're going to be compensated with. Even an administrator in the state of New York is entitled to be compensated. So anybody who volunteers or agree that they're going to be serving as an administrator under someone's estate, that person is also entitled to compensation as an administrator, because you're doing work. There's a lot of work to be done under an estate, including you have to know how to do accounting, or you hire someone to do the accounting for the estate. So these are all things you need to do, and you need not leave your property to chance. You leave your property to chance, people are going to fight over your estate, and people are going to decide what happens to that estate. So the best thing is to do is you take the initiative now, prepare a will that if anything, if and when something happens, that estate will be divided in the way you want it to go. It'll go to whoever you choose to send it to, versus it going to who the state says it goes to. So if you thinking that you have assets and you don't have all of the right people that you want to inherit, because you don't have wife, children, any of those things. Or let's say you have an ex-wife. Some people would like to spite their exes, and instead of benefiting their ex, what they will typically do is just not benefit the ex, or decide that you're not entitled to anything from my estate. So because you're not, I don't want you to get anything. I'm going to change the will. A lot of people prepare a will during their lifetime, and then they realize as they get older, things changes, the terms changes, the situation change. And there's instances where people created a will when they were married, and then they got divorced and they forgot to change the will. And if you forget to change that will, guess what happened? The persons who you have named under there to benefit from that will end up benefiting. You got to remember, if you would like to change, if you already have a will and you would like to change the terms of the will, you have to create a codicil. The codicil will amend certain parts of the will without revoking the entire will. So for instance, like I said earlier, if you were married and you made a will and then you got divorced, you could make a codicil revoking the portion of the will that give assets to your ex-spouse, and make it so that only whoever you would like to benefit would benefit, and that's it. So the codicil is a very important tool when it comes to will, creating a will, making sure that you benefit the right people under your will. If you would like to leave your assets to charity, a will is a good option. If you would like to leave it to different distant relatives, or even you might have a pet, which I don't recommend, but people can choose to do whatever they want. It's their assets. So if you want to ask the question, should you do a will or should you do a trust? When is it best to do the trust versus doing the will? There's different circumstances determining which one is best for you and why you should use one versus the other. And one of that being under the will, like I said earlier, the will is more appropriate when you don't have close relatives that you would like to benefit. You don't have a wife, you don't have children, and you just want to benefit distant family. So you really don't care what happens while you're not here. But if you do have children, you do have a spouse, and those people you would like to benefit, the best thing is to create a trust. Because if you create that trust, it means that on your death, there would be no problem for them to have to go and probate a will. And to probate a will, in most instances, the beneficiary has to come up with the funds to pay the attorney, so the attorney could probate that will and then have the assets sold or whatever you intend to do with that asset. But on the other hand, if you decide, you know what, I don't want to put my beneficiaries through this type of stress, because it's your children, it's your spouse, it's people who are close to you, and you don't want to put them to cost in the event you're gone before them. You want them to be able to have a smooth transition as it relates to your asset. The best thing would be is to create a trust, put the assets in a trust, so anything happens to the testator, no probate will be required under a trust. You will cut that entire process out, and your beneficiaries are going to be able to save money, save time, and everything else by not having to probate your estate. But like I said, people shouldn't be intimidated or concerned when you hear the word will, because it's not that you're preparing for anything. It's just that you're preparing for when when the time eventually comes. If it's 100 years from now, then it will be a smooth transitions for your beneficiaries, and they wouldn't have to go through the whole stress of having to obtain probate. Now, probate is a good idea if you living in Guyana in particular, because one of the things about Guyana is the structure or the system that we have in the United States. They don't really have that in Guyana, because I told you earlier in one of my other videos where I spoke about a trust, that there's a rule against perpetuity. So a trust in Guyana cannot continue in perpetuity. A trust in Guyana could only end at the time the last person to be born when that trust was created. So you cannot create a trust in Guyana that affects somebody in the distant future. You can't say, okay, I'm going to benefit my great great grandchild who's not even born yet at the time I'm creating the trust. The rules against perpetuity would defeat your trust, and your trust would be inoperative. Versus if you created a will in Guyana, you could actually do a will, and the people under the will in Guyana has to be identifiable. They require that, because you could describe them any way you want. You could say $50,000 to my grandchild, and at the time you created the will, your grandchild, everyone knew who that grandchild was. The person has to be identifiable. You see, the Guyanese law came out of the British system, and the British system, I think, is so much different from the system that we use in the United States, in that it operates in a way that if you're benefiting someone, the person has to be, we got to be able to identify that person. We have to be able to point to that person based on a name or a description in a will. But if you can't identify the person based on the description or the name that the person used, then that becomes a problem. And this is why the Guyanese law has to rule against perpetuity, because you can't identify that person, that distant person who's not even born yet, under a trust. Whereas in the United States, we have no such problem. We could use a trust indefinitely, and it could benefit our family for generation upon generation upon generations to come. I think everybody knows about the Hershey's Trust. The Hershey's operate under a trust, even though the people who found Hershey's, the chocolate that you eat and you don't even know where it came from, the Hershey's Family Trust is still going. Hershey's been dead for I don't know, hundreds of years or whatever. He's been dead, and that trust is continuing and it's benefiting our orphan boys. They have a system where they benefit, boys from different background and different parts of society. But that's the way a trust operates in the United States. You can use it continuously to benefit generation upon generation, or whoever you choose to benefit under that trust. And that's why I say a trust is always better when you're benefiting your family, because whatever assets you put there could go on and on and on and on and on until the trust eventually takes a death of his own. Personally, at some point, one or two of the trustees under a trust might decide to sell the asset under the trust, and the beneficiaries may agree, and that would bring the trust to a natural end. But if that never happens and they just keep reappointing successive trustees, then the trust will go on and it will continue indefinitely. Versus there's different types of trust anyway. But when we speak about, like, for instance, an irrevocable trust, the ones that you can't revoke, those can continue indefinitely, and there's no debt to it unless I say the assets under the trust are either disposed of by the trustee. And if the assets are going to be disposed of, everybody has to agree. There's provisions in some of the trusts making the trustees' jobs a little bit more difficult. There's some trusts where the trustee does not require consent from anyone, and the trustee could act independent of anyone and sell the assets or do whatever they want to manage that asset. But some trusts, you can restrict your trustees' rights to do things without the consent either of the beneficiaries or the consent of the settler if the settler is still alive. I often advise most of my clients to put restrictions in the trust on the trustee's ability to dispose of any asset without the settler's consent, because there are cases where the trustee can sell the house. If it's a house, you have to transfer that house into the trustee's name. The trustee holds the property in trust for the benefit of the beneficiaries or whoever are entitled to benefit under the trust. And in so doing, you give that trustee the power to act, in some cases independently, to sell, to dispose, to mortgage, do whatever it takes to manage that asset under the trust. And in order to prevent that trustee from doing anything crazy, I always advise people that put restrictions in your trust. Every trust I create for my clients, I make sure it has the appropriate restrictions that they're looking for. A lot of times people use the trust because they're just trying to protect the asset in the event they would like to get Medicare in the United States. There's a system here in the United States where you could get charity if you have some sort of, if you have multiple comorbidity and you might have the need for a nursing home and you own a property. Just note, when you get to a certain age, what they do is they put a lien on that property if you accept social services. And once that lien goes on that property, it stays there for the duration of the time you continue to take social services. And then when you die, that the state of New York will have a lien on your estate for whatever amount you took from the state. So usually I tell people, don't keep the asset in your name if you're going to get social services. Put it into a trust. Or the other way you can protect it is by using a life tenancy on your deed, because the most popular asset that people try to protect is a house. Most people have a house, they want to protect it. And I think that's one of the most important ways that people in our community use to pass down wealth from generation to generation to generation is real estate asset. So if you have a real estate asset and you're trying to protect that, the most common sense thing to do is create a trust. Don't pass it under a will. Because like I said to you before, the will is only helpful if you don't have closely related beneficiaries who are depending on you to pass those assets down. If you have closely related people, always go for a trust. If it's just a case like, some people have no one, their mother died, their father died, their brothers and sisters are all gone, and it's just them and they never had children, it doesn't matter. You can create a will. A will would be the most appropriate thing. And so let the beneficiaries who you're going to benefit go probate your estate and take care of that. And there's in the state of New York, you don't have to pay taxes if your estate is below a threshold amount. If it gets above the threshold amount, then you have to pay taxes on that estate. And those estates is multi-million dollars estate that has to end up paying taxes. The smaller estates, no, they don't really have to pay taxes, because if it's below the threshold, then neither the state of New York nor the federal government would tax that estate. It has to be over the amount that the law permits. Then you're going to have to pay estate taxes on that. And it's very few people I see in our community that reach the threshold where they'll have to pay taxes, because the estate literally have to be multi-million dollars. Like, it has to be a lot. And then you have to pay the percentage worth in taxes. So guys, like I said, just today, if you're just joining us today, we are discussing a will versus a trust, on whether or not it's a good idea to have a will for your estate, or should you go with a trust? And like I said, it's always better when you don't have closely related beneficiaries to go with a will. Create a will, leave your assets to those people, because either way, you don't care. They're distant related people. I've had instances where a client created a will, and he left his property to a woman that he wasn't even related to. He was of sound mind. Everything was right, perfectly fine with him. But after his death, the family came in and tried to argue. They tried to say, oh, she used fraud, this, that, that. They tried to get over in terms of asking the court. The court denied those people. They were denied. They never succeeded in getting any of those assets out of the will. The man left his will. Those were his wishes, that his assets must go to this woman he was not related to. His family was extremely upset. But I tell you what, a lot of times people have family that they don't even look at. They don't even care the family exists. They don't go and see them in the hospital if they're sick. They don't go visit them at their home. But the minute that family dies and the family know that there's assets involved, then they just show up out of nowhere and they would like to have their interest. But it doesn't necessarily work like that, because the court looked for certain things to determine whether or not it should invalidate that will. And in most cases, the will would not be invalidated because those were the wishes of that testator. That testator intended, his or her intentions were that their asset go to this person. And especially when the court look and see the testator understood the extent and the nature of his bounty, he understood that whoever were supposed to benefit from it, and he willingly choose to disinherit those people, it will be a difficult or impossible hurdle for anyone to get over and to invalidate a testator's wishes or the testatrix wishes. Likely, more than likely, the court will deny anybody's petition to ask that the court invalidate a will, especially when it's clear there's no fraud, there's no duress. The person was of their sound mind, they understood, and they make independent decisions. It will be difficult to get over that hurdle and invalidate anybody's will. So the best thing is to do, if you know that you have closely related relatives and you would like to benefit them, or even if you want to give a stranger, a random stranger, your estate, create the will, right? Create the will. The testator should create the will, but the testator obviously wouldn't care once he or her is no longer here. What happens if there's fighting? Or they could naturally do a life estate, transfer over the property. I saw once it was this 90-something-year-old woman. She only had a niece. She fell out with the niece, so the niece and her separated and go their own ways. The niece doesn't even talk to the lady. And then there's a neighbor who came in. I don't know how the neighbor got to get close with the 90-something-year-old woman, but I saw her. She came to the office a couple of times. She was using a walker, but otherwise she was of good sound mind. And she wanted to make a will. And I counseled her. I tell her, I hope you're sure this is what you would like to do. She said she's going to think about it. I told the neighbor, you cannot come into the client meeting with her because this is privilege and I can only be in this meeting with my client to the exclusion of you, because I don't want there to be any sign of you trying to influence this lady. So what the neighbor did, the neighbor went to a firm in Manhattan. She go to a firm in Manhattan and had the people create the will there, because the people there didn't care. They didn't ask any questions. And what she also did is she transferred the lady's property to herself. Now, whereas Denise is nowhere around, Denise doesn't communicate with her grandmother, with her aunt. She doesn't even know what's happening. But right under her nose, the neighbor, who, by the way, have her own property, you understand? The neighbor took the asset, transferred it to her, and leave this 90-something-year-old woman. Whereas when the woman was my client, she alluded to me that she would want to sell the property at some point, but she would like to make a will. But there's a possibility that she would sell the asset and take her money and go rent an apartment until she dies and use the money maybe to travel or whatever is it she intended to do. She worked very hard during her life. She was a nurse. So my guess is that she wanted to, do something. But the neighbor went, and I don't know if the neighbor used any fraud or duress, but I can see clearly when the lady came to me that she was indecisive about putting the property under the will or whether she was going to sell it, but there was no talks about giving it to the neighbor. She wanted to leave it to her niece, but the neighbor swooped in and was able to convince her. I don't know how, but if the niece could ever be found, if she could ever be found, she would need to go now before her aunt dies and take steps to get that property back from the neighbor. Because once that aunt is dead, it's going to be hell to get the property back from the neighbor or even get anything done. Chances are the niece is disinherited. So you got to be careful when you have elderly family members and they have assets, and you want to make sure that those assets are left to you. You got to be very careful. You can get the assets transferred during the lifetime of those family, or make sure that they make a will or they do a life estate, transfer the property over to you and retain a life estate to themselves. And there's other instances I know where clients just made a life estate deed to family members because they were very, very sick and they were anticipating that they were not going to make it. So they transfer out the asset while they're alive and retain a life estate to themselves. And I think that's a good way to go, because in some cases the client doesn't have children, the spouse had already died, the stepchild or child had already gone, so it was just the client remaining. So the client did a life estate deed so that whenever she's gone, her family, her nephew, or whoever she give the property to would have no responsibility in terms of going and have to figure out, okay, I have to probate the will. Probating is a lengthy process sometimes, and it could cost you a lot of money. There's some counties in the state of New York that process letters of testamentary or letters of administration pretty quickly, so you don't have to wait. There's some counties, likewise in New Jersey, it moves pretty fast. You can get letters within 30 days or less. But in Kings County, on the other hand, it can take you months to get that letters. And in Kings County, mostly you need it because there's a unique system that operates there in terms of when the biggest asset is real estate, most likely there will be tenants in there. And then you have to figure out, how do you evict the tenant? You have to wait on preliminary letters. You have to apply for preliminary and full letters, because chances are you'll get the preliminary first and you'll be able to evict the tenant. And then after you get the full letters, then you'll be able, if the tenants are gone, then you'll be able to sell the property. But most likely the tenants will not be gone, because we have a unique system with the landlord and tenant in Brooklyn, in Kings County. Kings County is the worst, and I'm hoping at some point they'll revamp the system. Even Queens is better with evicting tenants than Kings County is. Kings County is the worst county when it comes to evicting tenants from your property. So it's a very, very unique situation. Anyway, guys, I thank you so much again for joining me this week on The Law and You. I bring you this program every week at Saturday at 4 p.m. It comes to you based on the compliments of the Washington law firm. I encourage you to like these videos and share it. Share the videos at all times, guys. If you want me to continue to bring you content, like and share, like and share. And also, what you should do, if there's something that you would like for me to talk about in this program, you can send me a message, okay, and I will respond to it, or I will discuss that topic on the following week. Also, if during these programs you want legal advice, you can call that number right there, 718-877-3100. And not for consultation, but if you have a legal question that you would like to ask, that you would like the public to know about, you can call the number that you see across the screen, 718-877-3100, and we can discuss it here live on the show. So starting next week, bring your questions. You can call the number and we can discuss it, guys. Thank you for joining me again this week on The Law and You. I will see you again next week at Saturday at 4 p.m. Thank you, guys. Enjoy the rest of your weekend. Thank you. See you next Saturday.